In this video, I'll be providing some feedback on a student draft essay introduction. And hopefully from there, you'll be able to take away some key tips about how to improve your own law essay introductions. So before I get started, I thought what I'd do is just briefly talk you through 5 of the key tips I teach my students when talking to them about how to improve their introductions. So the first tip is that it's good to provide context and ease your markup into your paper. And what I mean by that is at the start of your paper, say the first 1 to 3 sentences, you might like to provide some contextual information, some background information that sets the scene for the arguments to come. Then in terms of our next tip, tip 2, make it obvious you're answering the question. Now, this might be itself an obvious thing to say. However, probably, I don't know, at least a third of the papers that I read don't directly answer the question in their introduction. And so, as a result, their thesis isn't being clearly expressed and or linked back to the question they've actually been asked to answer. So once you have drafted your introduction, I think it's super helpful to go back, read the introduction and just think, if I didn't know what the question was, would I be able to tell what the question is by reading my introduction? And if you can't, you might like to go back and just have that one last redraft, which makes it super clear that not only are you putting forward an essay, but you're putting forward an essay that responds to the question that you've actually been set. In terms of the next little bit of feedback here, be specific. This is something I write on many student essay papers, and particularly so in the introduction. So what I mean by be specific is essentially you need to be as upfront as possible about your paper and the arguments you make in it. And also what your paper actually looks at, what the scope of your paper is. What do you do? What do you argue? What do you conclude? Give me all that information up front in the introduction. Be specific. I don't want any surprises whatsoever as I'm reading through your paper. I want to know exactly where you're going to take me after reading that first 100 or 200 words. Okay. In terms of the next tip there, provide a roadmap or outline the scope of your paper. You could do this by literally writing in section 1, this paper will. In section 2, this paper will do this and it will argue A, B, C. You can do it as obviously as that, but you could also outline the scope of your paper in a bit more of an indirect way. And it doesn't bother me as your marker which one you do. However, I do want to know exactly what your paper looks at. And that ties back to our last tip around specificity being important. The final tip about improving essay introductions that I have is that it's really important to state your conclusions at the outset. So if your paper suggests a reform option, tell me what that reform option is. As I mentioned, I don't like surprises. I want to know everything at the outset. And in some essays, keep in mind, stating the conclusion can literally be around stating your thesis clearly, stating whether you agree with the question or disagree with the question or somewhere in the middle. So in your introduction, set the scene, make it clear that you're answering the question, be as specific as you can as to your scope and your arguments and your conclusions. Okay. So with all of these tips in mind, we're now going to have a look at a particular student paper that I marked recently. All right, so you can see with the question here, I was essentially asking my contract law students to assess the viability or the desirability of abolishing this particular doctrine. Now, this was a very short essay task. I only gave the students 1,100 words maximum to put forward an argument in response to this question. All right, so this was the question I gave my students. Here is a student's first draft in response to this particular question. Okay, if we have a look at their first, let's have a look at their first 5 sentences. Okay, so there's a general reluctance to enshrine economic duress as a doctrine under Australian law. Our natural sympathies often lie with the underdog, producing an inherent tension in the law whereby courts espouse principles of freedom to contract while seeking to mitigate the effects of unequal bargaining power. So students identifying a little bit of a tension there. Then they're talking about the development of this doctrine of economic duress generally. Then they're talking about its key elements generally, and then what the party must prove in order to be successful generally. Okay, so this entire first section here is a whole lot of background information or contextual information. Now, if you remember back to my tip slide, you will have noticed I said between 1 and 3 sentences of contextual information. And also that it's a really good idea to be strategic about the information that you provide. So linking it closely with the arguments that follow is your strongest way to set that scene for your marker. Here, I would argue that what the student has done is given us too much contextual information, and also it's lacking some focus. So I don't get a clear sense necessarily of where the student is going with their paper. Are they focusing on the tension? Are they focusing on the difference in development across different jurisdictions? Are they talking about the reluctance of the court to rely upon this doctrine in their findings? Like, what is it that's relevant? And it's not immediately obvious, which is something that I would argue is a little bit problematic. Now, let's move forward. So beyond this uncontroversial criterion, 3 issues remain clear. What counts as illegitimate pressure, the causal link, consent, voluntariness. Okay, so essentially here, the student is talking about or linking back to particular areas of principle, okay, causation, pressure, whether consent was there to enter into the contract. Now, once again, this is not super helpful. It doesn't tell us which is the focus of the paper to come, and it doesn't tell us what the particular problem or critique is with this particular area or areas of this doctrine. So I would argue that this is one of those moments where the student could have been more specific. The other problem I have is that so far we don't have a clear sense of the question that the student is answering, which was essentially a question of should we get rid of this doctrine or not. All I have so far is general information about the doctrine and general information about its elements. So the positioning of the student, their thesis on the question, is not clear as yet at all. But you'll notice the writing itself is fine. Like the student has gone to effort. I can tell that they've spent some time constructing their sentences, etc. But if we think about an essay as an argument in response to a question, their content isn't being framed in an effective manner yet. Okay? All right. Then in their final sentence, the student's discussion is quite general once again. Okay, so they're seeking to critically examine the validity of the doctrine, okay, and deconstructing the issue. Whoa. Deconstructing the issues surrounding the doctrine. Once again, I've got a problem with specificity here. Critically examining something doesn't tell me what you're arguing in response to whether the doctrine should stay or go. And also deconstructing issues doesn't tell me what issues are the focus of your paper. Okay, so the student has written some information in their introduction, which is generally on track, generally links to the legal propositions that are relevant, but it actually tells us very, very little about the paper that comes. Okay, so let us look at the next slide then, which was their second draft after they'd attended a workshop with me around writing, research and writing. Okay, let's see how they went. Okay, so we've got in their first sentence here, we've got some of that same content from the previous slide. So we have some background information again, albeit less this time. We have some background information again around reluctance to enshrine the doctrine in Australia. We have a tension that the courts are faced with, and we have the development of the doctrine across jurisdictions. So I would argue that although the student has cut down this information, this contextual information, it still is probably too lengthy, and in my opinion it is too lengthy, particularly for a 1,000 word essay where, you know, every word matters. So it is still too lengthy, but it is slightly more focused than the previous example. But it's the back half of the introduction where the student has made some key and I would argue important changes, although there's still some room for improvement. So let's have a look at the backup. Okay, there is significant discussion in the literature and in Obiter proposing to merge this doctrine within the wider ambit of unconscionable conduct. Okay, all of a sudden, I'm starting to get excited. What the student is doing is setting the scene for the arguments that follow. They're telling us that they're going to be discussing duress and the need for it in relation to another doctrine over here. So that already tells me more about the scope and the potential arguments to come in this paper than what the previous introduction did. So I'm really glad that the student added this additional clarity. Then in their final sentence, the student has this essay seeks to critically examine the validity of economic duress as a cause of action. Suddenly I have a little bit more of a reference to the question, so there's that little bit more clarity around the positioning of the essay in response to the question that's actually been set. And then the student has what they actually argue. They're going to argue that such a merger would result in a more principled and consistent relief in defence of freedom of contract. So I suddenly have a greater sense of their arguments. I have a greater sense of the question that they're answering. I have more specificity around this other area of law, which is going to inform the arguments made over here. So what I would argue is this second draft is a vast improvement on the previous in terms of specificity and argument and responding to the question. They could potentially have been a little bit more upfront around their conclusions, but because they mention their argument, you know, you can kind of infer, okay, that's the key argument, that's the thesis statement. But whilst all of those tips are coming through more strongly in this second draft, I would argue that they still need to work on their background information, their contextual information, and being a little bit more strategic. So rather than saying there is a general reluctance to enshrine economic duress, tell me what people see the problem as with economic duress. And that is particularly helpful if you then obviously go on to argue that these problems are part of the picture as to why you think the doctrine should move in this particular direction that you're putting forward. So yeah, so here we have it. We've got an improvement in the student drafts. They've still got a little bit of way to go, but we're moving in the right direction. So hopefully you found this video informative when thinking about how you can improve your own introductions. Okay, thank you.